Hello, everyone, and welcome to the Minnesota Office of Cannabis Management's press conference to discuss the next steps in the licensing process. I'm Jim Walker, OCM Public Information Officer. In just a moment, I will introduce OCM Interim Director Charlene Briner, who will outline our process. We have 30 minutes reserved for the entirety of the press conference. You will all be muted with cameras off until Ms. Briner's statement is complete. At that time, if any members of the news media have a question to ask her, please use the raise your hand feature at the top of your screen. I will introduce you, unmute you, and turn on your video for you to ask your question in the order your hand was raised. If we cannot get to your question due to time constraints, please refer to the press release that went out prior to this event, or you can contact me after the call. With that, I now open this up to Interim Director Charlene Briner. Charlene?
Thanks, Jim. Good morning, everyone. We appreciate you joining us as we share next steps in our plans to launch Minnesota's adult use cannabis market. When OCM began planning for the licensing pre-approval process immediately following the 2024 legislative session, we took a very deliberate approach to the lens we would use to review applications. That was based on the feedback of both legislators and advocates. I've actually got window cleaners outside at this very moment. We took a very deliberate approach to the lens we would use to review applications, and that was based on feedback of both legislators and advocates. That approach was predicated on a rigorous application and multi-phase review process that would do two things. It would ensure a baseline of readiness in this first pool of licensed applicants. And number two, it would demonstrate our commitment to identifying predatory practices and other tactics that we've seen in other states from applicants who attempt to gain unfair advantage in the first licensing lottery. We stand by that approach, and we believe it was the correct way to operationalize the pre-approval portion of the law. However, as you know, last month a Ramsey County District Court judge issued a stay, which halted the license pre-approval lottery that was planned for November 26th. That decision left 648 qualified social equity applicants in limbo. It prevents them from moving forward toward receiving a business license, and it leaves them with understandable questions about what happens next. A protracted period of uncertainty is an unacceptable outcome that could diminish the opportunity for social equity applicants to succeed in this market. And it also jeopardizes the Office of Cannabis Management's stated goal of launching the market in 2025. We remain committed to ensuring that qualified applicants have a clear path forward and are given consideration in the next licensing cycle. After extensive evaluation of all of the options available to us, we've identified a path forward that will avoid further delay to market launch, and it will minimize, at least to some degree, further risks to the social equity provisions in pre-approval that were envisioned by the legislature. Today, we're announcing the end of the license pre-approval process and the timeline for a standard licensing cycle for both social equity and general applicants. This cycle will begin on January 15th of 2025 with a 2-week window that will allow prospective applicants to become verified as social equity applicants if they have not already done so. Followed in February, on February 18th and running through March 14th, we will accept applications from both social equity applicants and general applicants. That licensing cycle will culminate in a lottery for capped license types in May or June of next year, depending on the number of applications we received and the amount of time it takes to conduct a rigorous review. There's a timeline in your press release that was sent out just a few minutes ago with important dates, and we'll be posting that timeline on our website as well. The decision to end license pre-approval process and move forward with standard licensing shortly after the new year has two primary benefits. It preserves, at least in part, some of the early mover advantages for social equity applicants that were envisioned by the legislature in that pre-approval process. And secondly, it also keeps us moving forward towards a timely market launch in 2025. I don't want to sugarcoat this, that 648 social equity applicants who qualified and were expecting to participate in the lottery are understandably disappointed, which is why we want to be very clear with them about their next steps in this process. Those 648 applicants who are deemed qualified in pre-approval will automatically be moved forward in the standard licensing cycle. They will have no additional application fee, and they will not be required to resubmit an application. For those 648 applicants, of those that applied for a license type that will not be capped in statute in the standard licensing round, that includes micro businesses, which do allow for cultivation, they will continue their next steps in securing a license. Those applicants who are seeking a license that is capped will be subject to a lottery and will be automatically entered into the social equity lottery. If they are not selected in that lottery, they will automatically be moved to the general lottery, where they will have another opportunity to be selected as a licensee. For applicants who receive denial notices during the pre-approval process, they will have two options available to them. They may choose, first of all, to discontinue participation in the next licensing cycle and request a refund of their application fee. Requesting a refund and not proceeding at this time does not preclude them from participating in future licensing opportunities. If they do not choose to request a refund, they can choose to move forward in the standard licensing cycle. And I think it's important to note that that statutory process is distinctly different from license pre-approval, which had greater time constraints and was oriented toward assessing readiness of applicants for the marketplace in the immediate future. In the standard licensing cycle, OCM will send requests for more information to applicants who were denied in pre-approval, and they will have an opportunity to correct a broader range of issues in their applications, and will also have the opportunity for reconsideration, which was not available to them in the pre-approval process. While the impact of this plan on pending lawsuits is a decision for the courts to make, we believe this approach will allow for the licensing of cannabis businesses to proceed without additional delay, without ambiguity, and will allow OCM to issue licenses as early as possible in 2025. The Office of Cannabis Management remains committed to upholding the high standards and expectations in the law that establish an adult use cannabis industry. We will not waver in our efforts from licensing to enforcement to consumer education in our goals of a market that operates with credibility, accountability, and that consumers can trust is safe. We will maintain rigorous review for these clear standards and will continue to work with our partner agencies to identify actions that are in violation of the true party of interest provisions in Chapter 342. And when necessary, we will pursue all legal recourse available. While this announcement today does not fully address the disappointment of the 648 qualified applicants who expected to be entered into a lottery on November 26th, our commitments to the principles of social equity is undiminished, and those principles are central to this new path forward. I have said often that Minnesota doesn't bear the burden of being the first state to legalize adult use cannabis. We're not the first state to license and regulate a new cannabis industry. However, we do bear the responsibility to carry out our obligation and our statutory charge in a manner that is consistent with the unique provisions of Minnesota's law that place equity, market integrity, and sustainability at the fore. And with that, I am happy to take questions about our plan. I'm going to turn it back to Jim, who will facilitate the Q&A process.
Thank you, Charlene. As stated, please use the raise your hand feature at the top. And I'm already getting a few people here. So I see I would go with, I think I saw Peter Callahan first from
Jim,
MinPost. Let me
Jim, it
just,
looks like Caroline had her hand up first. I'm looking at Caroline, Peter, Evanberg, and then Corin. So maybe we can go in that order.
I apologize. Here we go.
So Caroline, how about you?
Caroline, are you able to speak?
Can you hear me okay?
Sure can.
Okay. A couple things. One, how do you square bypassing, if you will, the pre-approval process with the fact that that was in statute requiring such a thing? And then two, can you say a little bit more about how somebody who might have been denied in social equity pre-approval could move on to general licensing? So that is to say, somebody who was rejected for the reasons that you had mentioned about, flooding the zone or kind of using a straw buyer, if you will, a straw applicant. Could those people, are those rules less stringent, it sounds like, in general licensing, or is it the scope of the documents you have to submit less stringent at that time?
Okay, so that was a lot to unpack in that question. I'm going to take the first one first. Pre-approval is discretionary in statute. So the statute is very clear that the office may conduct a pre-approval round. It is not a requirement in statute. And so we believe that because it is discretionary and not a statutory mandate, that we have the ability to end the process today. Second of all, as I have said, we are committed to using all of the tools that the legislature gave us to root out bad actors who would attempt to game the system for unfair advantage. That means we have both a rigorous front-end review and a back-end review process that will help us do that. Additionally, the standards for application, the requirements for submission are the same. The lens that we used to determine denial were predicated on the lens that I talked about, which was both moving quickly in a pre-approval round and holding to a high standard of readiness. Those standards are the same in terms of submission requirements. However, I think that there is the opportunity to have a broader range of opportunity. There is a wider range of opportunity to correct issues on an application that was not available in pre-approval. The statutes are distinctly different. The statute is distinctly different when it talks about pre-approval and when it talks about the standard licensing process. And primarily, it does allow for that broader range of issues to be identified and addressed, and it does allow for a reconsideration, or essentially, it's not called an appeal, I don't believe, but it essentially gives an opportunity to appeal a denial or a decision of the office. That was not available in pre-approval.
Thank you.
All right, next I see Peter Callahan.
Hi, Peter. I think we need to unmute Peter.
Okay.
Here we go, Peter.
Yep.
Yeah.
Can you clarify for me what are there two lotteries still that might happen in the May-June period? Are these sequential? Presumably you do social equity first, so they have an opportunity to enter the general. And can you remind us of the license numbers in those two lotteries?
So there are 4 license types that will be subject to lottery. So 4 that are capped in statute. Peter, it is, I don't have it in front of me, but off the top of my head, it's cultivator, mesobusiness, is it manufacturer? Josh or Jim can follow up with you on those license types. And yes, we anticipate there will be sequential lotteries. So for the license types, among those 4 license types, we would conduct a social equity lottery first, followed by a standard or a general license in which those applicants not selected in the social equity process would be entered into that second lottery. Whether that happens in the morning or the afternoon, or one day followed by another, or even a week followed by another, we're still planning, and that is also dependent on the volume of applications that we actually get in those license types.
But you had numbers capped for social equity. I forget, is it 240?
Uh-huh.
What is the additional license numbers for a general lottery?
So if you recall in statute, there's 50% of licenses reviewed for social equity licensees and 50% reserved for general applicants or general licensees. The pre-approval process was half of the 50%. So 25% of the social equity licenses reserved. So you double that. So there'll be 500 and some in the social equity round, and then subject to the caps, a similar amount, or the other 50% in the general round.
Thanks.
You bet.
I see Evan Berg.
You know what?
Having some.
I think Corin
slowness with the mic.
I think we need to go to Corin, and then I'm not sure how the numbers are playing out. I'll let you facilitate, Jim.
I have Evan first, and then Corin, then Ryan Raish.
Great. Hi, Evan.
Okay. Oh, hi there. I'll keep this quick so we can keep moving along the line. Before today, just with the initial lottery plans being put on hold, there was a lot of uncertainty about the whole process. I think you've clarified a lot of this. Is there anything else you'd want potential applicants to maybe just keep in mind as they're just approaching this under the new timeline?
I think what I would say is, number one, keep an eye on your email today, because we're going to be communicating with everyone who was in the just ended pre-approval round. So keep an eye on your email. We're going to put the timeline up so that people have certainty about that. I think I would want to share with the 648 applicants our disappointment. This was certainly not an outcome that we were hoping would materialize. And we know that today's path forward does not provide a perfect solution, but I'm hoping that they will take some comfort in seeing that there is a clear path forward, particularly for those applicants who applied for an uncapped license type, and that they will continue to reach out and look at the resources we make available so that they are very clear in their next step on the licensing journey.
All right, next I see Corin Hoggard, KMSP.
Hi, I've got a few, but I'll just ask one and then I'll get back in queue, basically. Let me start by just from the lotteries, whenever they occur in May and or June, how long from the lottery to actual handing out of licenses and people starting their businesses?
Corin, that's right. That's an individual business decision. I think that it depends on how prepared they are to go in the next step. So what happens after the lottery, or what happens to applicants who are not subject to lottery in terms of next steps? They have a couple of things they need to do. Number one, they need to make sure that they have updated and secured a labor peace agreement. They have to go through a background study. And then they have to make sure that they are in compliance with local zoning ordinances. Once we get all of that information back and confirmation from the local, we do a pre-opening inspection. And so theoretically, if people have everything lined up, if they're already working with their locals, if they have been working with a labor organization to get a labor peace agreement, people could move forward with this in a matter of weeks or even months, right? But if they still have a lot of planning to do, remember the pre-approval process was as much about allowing applicants some certainty to be able to secure financing, to get a building in place, and to make all of those other business decisions. So theoretically, people could be standing up and opening for business relatively quickly after we open that approval, or for cap license types after we conduct the lottery. But it's really, again, an individual business decision for each business operator.
Thanks. I'll get back in line.
Great.
Next I see Ryan Raish, KSTP.
Hi, Ryan.
You have to open up your mic too.
Sorry, can you hear me now?
Sure can.
All right, thanks for taking my question. It's my understanding that now you're facing legal challenges from both those who were approved and those who were denied for pre-approval. And now there's concern that, you called it discretionary on doing away with the pre-approval. There's some belief that you have to go forward with pre-approval once you started taking applications. How do you respond to that?
So obviously, Ryan, I'm not going to comment specifically on what the court may or may not determine, but the statute language is very clear that the office may conduct a pre-approval process.
And so is OCM still going to move forward with everything that's going on in court then?
We are moving forward with our announcement of the timeline for standard licensing. We are ending the pre-approval process today.
Okay, thanks for your time.
You bet.
Next, I see Michelle Griffith from the Minnesota Reformer.
Hi, Michelle.
Hi. So some of the applicants who filed suit alleged that they had heard that some folks were able to contact you personally and change some of the details in their application, and they themselves were not granted that opportunity. Can you respond to those allegations?
I would say that I have had dozens, if not hundreds of people reach out to me personally. When I receive those, I do not comment on licensing decisions. I forward them to my general counsel and I forward them to our chief regulatory officer who look into it. And then those responses are dealt with through customer service or the decisions of the leadership team. I don't know of anyone who has had a conversation with me that has influenced a licensing decision, because I am essentially not involved in individual decisions for licensees.
Thanks.
Mm-hmm.
I now see Evan Berg, KIMT.
Hi, just one quick follow-up about additional impacts of the initial delay here. I know some communities here in Southeast Minnesota, like Austin, were considering some ordinances on the original timeline. They decided to delay some of those ordinances that would allow them to sort of integrate new cannabis businesses in their community. Have you guys, as your department, had a lot of back and forth with communities like that, just as you've been navigating this new timeline?
We have lots of conversations with our local partners because they're a very important part of market launch. We have recently updated our local government guidance. That's on the website. Every local unit of government, cities, counties, townships, are taking a slightly different approach. Some have already passed and adopted their ordinances. Others are waiting until the local moratorium lifts on January 1st of 2025. I think that today's announcement will actually help a lot of the locals and give them some certainty about timeline as they continue their planning and adopting their own local ordinances.
All right, thank you.
And next I see Corin Hoggard, KMSP.
Thank you again. So there's 648 who qualified as social equity, but now the rest can go back and potentially correct anything that needed correcting, or in some of their opinions, show OCM where it made errors that excluded them, correct? Is there a thought to, having just allowed that process to play out and continuing with the pre-approval lottery here, can you explain maybe why that isn't happening?
So the pre-approval process was distinctly different. So there was a smaller universe of what could be identified as opportunities to cure, for lack of a better term. And there was no request or right to reconsider or to do an extended back and forth with applicants to cure those applications. So the standard licensing process is quite different. It is distinctly different, and we will be able to provide additional information to applicants about issues that may need to be addressed. I would say that we were very clear, knowing that there was no right for reconsideration and no right to appeal in pre-approval. We were very intentional and specific with the resource materials we gave to applicants before they applied. And every denial that went out specifically was tied to an item in the matrix. And so we did give information to applicants about reasons for denial, but we also know that that process is very different from the standard licensing process. The requirements and the standards are not different, but the process itself is different in statute.
Hello, everyone. This is Jim Walker again. We are now at the 5-minute mark, getting very close to time. So if you have any additional questions at this time, please refer to the press release, or you can contact me via email after this call, and I can coordinate responses. So on behalf of the OCM and Interim Director Charlene Briner, I would like to thank you, and we'd like you to have a good day.
Thanks, everyone.